My lord, I'm appearing for the appellant.
Yep.
My lord, the questions of law raised are at page number 25.
You can see my name.
Number 2, KV Arvind.
Mr. You should properly formulate the substantial questions of law. See the manner in which you have mentioned in the memo. We have framed 4 substantial questions of law, right? And I have admitted your appeal. You should properly frame it. I mean, just see what have you done. Yes.
Lord's questions are at page number 7. Malad, the narrow dispute, Malad, here, Malad, is Malad, 115 JB Malad has undergone a Malad amendment. Malad, the tribunal holds that Malad, there is a shortfall of Malad advance tax payment. Malad, the tribunal and Malad, when the 115 JB book profit Malad is computed, the Honorable Supreme Court has held that Malad 234B interest Malad for shortfall of advance tax is leviable. Now the tribunal Malad holds that without that Malad, the 234B interest has arisen due to the retrospective amendment made to section 115 JB, and hence Malad, it is not leviable. Malad, the Honorable Supreme Court Malad, in another judgment Malad, in the case of Anjum Goshwala Malad, has clearly held that Malad 234B is a compensatory and mandatory interest. Malad, that subsequent amendment and liability Malad is a ground Malad for waiver of interest Malad in the conditions imposed under 119. But not for levy itself. That may be a good ground, Malad, for waiver of interest. Waiver, Malad, is different, Malad, from not to levy at all, Malad, is my submission. 1 and 2, Malads.
Counsel for the was on the question of admission. The appeal is admitted on following substantial questions. 1 and 2. Notice.
Appeal reading number 3, CM Subramani.
May I please, my lord, I appear Subramani, my lord.
Yes,
Matter pertains to land grabbing case, my lord. A complaint was filed. The special court took cognizance. My lord finds it on page 21, my lord. Paragraph.
One query for you. This order is applicable, right, under section 17A?
No, direct. I'll verify, but the last.
Please see. Section 17A of the Karnataka Land Grabbing Prohibition Act.
Yes, madam.
Please file an appeal. We will permit you to file an appeal.
Right. Earlier, we had filed a writ petition before this honorable court. There is in this case. Is it annexure B? Page 16.
Therefore, fine, but why we should entertain 17A, you know? There is a provision of appeal, right, by an amending act of 19th of October 2020, 17A provides for an appeal. Please file an appeal. Yes,
please.
Mark the presence. In this writ petition, the petitioner inter alia seeks the writ of certiorari for quashment of order dated 6/7/2021 passed by the special court under Karnataka Land Grabbing Act. Case number so and so, right? When the when a query was put to learned counsel for the petitioner as to whether an appeal lies under section 17 capital A of the Act against the opposite order, learned counsel for the petitioner fairly submitted that he be granted the liberty to avail of the remedy of an appeal. In view of opposite submission and in the facts of the case, the writ petition is disposed of with the liberty to the petitioner to file an appeal against the order dated 6/7/21 passed by special court in so and so. Needless to say that the appellant shall be, petitioner shall be entitled to the benefit of the principles contained in section 14 of the Limitation Act.
Grateful.
The aforesaid liberty.
Number 4, Sri Harish HP, Government Advocate.
Lordships, this is also a matter pertaining to taking cognizance of the land.
File an appeal.
Please, Lordships, with liberty, Lordships, maybe.
Liberty. Right.
Number 5, Sri Govindrai Kamath, Government Advocate.
Okay, for the appellant, my lord, this matter arises under the GST Act, my lord. The authorities have given an advance ruling holding that the plant and machinery classified by me is not a plant and machinery, it is a civil structure. They have to deprive me the benefit of input tax credit, madam. So this matter requires adjudication by this court, my lord, because there are no judicial precedents directly on this point what I have raised. But various interpretative measures, what interpreted by this court as well as other high courts, I cited. But instead of relying on the judicial precedents, my lord, they have relied on Wikipedia and interpreted their own conclusions, my lord. This requires judicial interpretation. Notice
on the case, learned counsel for the petitioner heard on the question of admission issue note.
Number 6, Sri A. Mahesh Chaudhary, Sri K.V. Arvind.
Your Lordship, I'm appearing for the appellant in this instant matter, Your Lordship. On the last date of hearing, this Honorable Court had directed me to produce a certified copy of Annex Sheet A, Your Lordship.
What? How much time do you need?
Your Lordship, I've applied for the certified copy. I haven't received it yet.
We are not all concerned with to apply. How much time you first sentence you should have said, I need 2 weeks or 3 weeks time. That's the end of the matter. Still you have not said anything.
Apologies, Your Lordship.
I'm appearing for this. I am appearing for that. I have applied this. How much time you want? You don't want any time. All right. Learned counsel for the petitioner does not seek any time.
3 weeks time may be granted, Your Lordship.
Why you are so slow, madam? What is it? 3 weeks. I mean, saying you take 1 minute.
Your Lordship, there's due to some connectivity issue, there was a lag in the internet, Your Lordship.
Serial 1 of list 1.
Government Advocate, Srimati S.R. Anuradha, Muhammad Tipu Sultan.
Your Lordship, on behalf of respondent number 2, 27. Your Lordship, serial number 1 time may be a week's time may be granted, Your Lordship.
Second list of the 20.
Serial number 7.
You are appearing for petitioner?
Yes, my lord.
What happened to the proceedings? Whether an order has been passed?
Yes, my lord. Earlier interim order was granted, my lord.
Oh. No order has been passed.
Earlier interim order of stay has been passed, my lord, in this case.
No. So what is the challenge to the proceeding? On what ground?
My lord, the proceedings initiated before the land grabbing court is challenged before your lordships in this present petition, my lord.
Yes, what ground? That's what we are asking.
My lord, the ground is there is a delay in lodging the proceedings, my lord. After 9 years, they have initiated the proceedings.
Is there any limitation?
It is a private land. It is a private land, my lord.
Is there any limitation prescribed? You said
My
9
lord,
years. Time limit prescribed.
Yes, my lord. In their petition filed before the land grabbing court at 71, cause of action. May I read?
Is there any period prescribed for filing a complaint, Mr. in the Act? No. Yes, Mr. State office objection to comply within 2 weeks.
Sri Natarajan. Number 9, Sri Joseph Anthony, Sri K. Rajshekar.
My lord, for the appellant in this matter, I request for a week's time. I'll take necessary steps, my lord.
counsel for the appellant takes a week's time to enable her to comply with the office.
Your Lordship, counsel for the appellant prays for 2 weeks' time, my lord.
Mr. E.I. Sanmati appears on behalf of Mr. E.N. J. Noralji and prays for the granted 2 weeks' time. Just after 2 weeks.
Your Lordship, connected matter ITA 241 of 21 is admitted, my lord. Your Lordship, this matter may be admitted. In the meanwhile, I will compile the office objections, my lord.
Like Mr. E.I. Sanmati learned counsel for the relevant. How much time, Mr.?
Your Lordship, 2 weeks' time may be granted, my lord.
Let office objection be complied with within 2 weeks. List along with ITA 241/2021.
Please,
right?
my lord. Please, my lord.
Number 12.
I'm appealing for appellant in this case, my lords. This case was reallocated to me, my lords. I filed my memo for appearance on 25/1/2022, my lords. Your lordships may kindly direct the office to show my name in the cause list, my lords. And your lordship,
What's your name?
Vanita KR, my lords. I'm representing Vanita KR, my lords.
What's your name?
Mayavati, my lords.
Learned counsel for the appellant submits that he has filed memo of appearance on behalf of the appellant. Office is directed to reflect her name as counsel.
And your lordships may kindly grant 4 weeks time to comply with the office objection, my lords. Please, my lords.
What?
There is so many office objection, my lords. We have to produce a typed copy of the annexures, my lords.
Let counsel for this appellant case one is granted 4 weeks time to
Sign ಮಾಡಲ್ಲ
this office objection.
ನೋಡಿ ಮಾಡ್ತೀನಿ
Grateful, my lords.
ಮಾಡಿಬಿಡೋಣ ಮಾಡಿಬಿಡೋಣ.
Number 13. CP Muppalla.
13 may appear for the petitioner, my lord. I request 1 week time to and my lord, in this I have also filed an application for seeking amendment of the prayer, my lord.
Next. This complete office objection.
Number 14. Sri Nursing Swami NS.
Next time.
Number 15. Srimati Maitre Krishnan. Sri K. Ariga.
Appearing for the petitioners, my lord, I pray for a week's time to comply with the office objections, my lords.
Number 15. Sri Hari Krishna Saila.
Your Lordship, serial number 16, I applied for the petitioner, Hari Krishna Holla. 2 weeks time is paid for, Your Lordship, to comply with the office objection.
Number 17. Sri Venkatram Reddy. Sri K.T. Govindan.
My lords, I appear on behalf of L. Venkatrama Reddy at serial number 17 and 18.
Please supply a copy to the creator.
The office objection has already been complied with, my lords. Memo
When
was
have you
filed.
supplied? When have you supplied the copy?
We have supplied the copies and a memo was filed before this honorable court to that effect.
Date.
On 11/1/2022, the copies were served and a memo was filed on 13/1/2022. And I also have the acknowledgement for the memo, my file, my lords.
No, your statement is sufficient, ma'am.
My lords, one final submission.
You are an officer of the court, we will rely on your statement.
There are 4 other connected matters, my lord, which may be posted along with these 2 matters.
What are these?
May I read out the numbers, my lords?
Note down the numbers.
Writ petition numbers 12018 of 2021, 11429 of 2021, 11381 of 2021, and 9090 of 2021, my lords.
Counsel for the petitioner submits that copy of the writ petition has already been supplied to learned counsel for the caveator on 11th of January 2022 and memo has been filed before this court on 13th of January 2022. So stop in view of opposite submission, office petition is ignored. This along with WP number in order in
Number 19, Sri
Counsel, in this case, counsel for petitioner has tested positive for COVID, my lord. 2 weeks time may be granted. Even our colleague has tested positive.
Stated at the bar that the counsel for petitioner is suffering from COVID in view of its submission.
2 weeks time.
Let the rate petition be lifted after 2 weeks.
Obligement.
20, Sri A.D. Raman, Government
I am for
Advocate.
petitioner in this case, Your Lordship. I press 1 week time to comply the office objections, Your Lordship.
Number 21, Sri Avinash Balakrishna.
My lord, I appear for the petitioner's counsel. Here, my lord, sorry. Here, my lord, what has happened is, my lord, there was a tender for, my lord, supply of, my lord, 183, my lord, metro cars. Page 57, my lords, your lords get that. 57. We were to, my lord, manufacture the cars in India. Those metro cars. We entered into, my lord, we floated a company, invested, my lord, 100 crores. What happened was, my lord, that time, my lord, the FDI, my lord, there was no bar. It was open, my lord, we could bring in, my lord, the monies. In, my lord, 2000, my lord, 18, press note, my lord, came to be issued. Sorry, 2020, my lord, 22/4/2020. Page 610, my lords, get that. 610, my lord, in the second volume. That, my lord, automatic, my lord, route was there. That was changed. My lord, the gazette, sorry. Please come to, my lord, para 2, my lord, at page 610.
Yes.
Non-resident entity can invest in India subject to FDI policy except those sectors and activities which are prohibited. However, an entity of a country which shares land border with India and where the beneficial owner of an investment into India is situated or is a citizen of such country can invest only under the government route. That means, my lord, we have to take permission. After bringing in 100 crores, this, my lord, press note came. We sought permission, my lord, 674. 614, sorry, 614, 672, 672. Central government rejects my, my lord, application. 672. Then what happened was, sorry. In the light of this, my lord, I, my lord, came back to Metro and, my lord, said I am willing to, my lord, enter into a local manufacturer and supply, or I am willing to, my lord, manufacture everything in China and bring it here. Alternatives, my lord, given by me are at page 684, my lord, 684. I'm sorry, I should have given a list of dates. I owe an apology. 684. My letter is there, my lord, where I specifically, my lord, said, I gave them two options. My lord, please come to, my lord, 684 bottom. Option 1, CRRC proposed to carry out the final assembly work, commission and testing work in any BMRCL so and so that the best possible local manufacturer set, train set can be ensured. Second option, my lord, we said we will manufacture, my lord, everything, my lord, in China and bring it here. Page 685, option 2. In order to ensure timely delivery and product quality, CRRC requests BMRCL to accept more number of train sets under so and so project to be manufactured at Nanjing factory. In the meanwhile, CRC shall continually pursue FDI and all that. They, my lord, do not, my lord, agree to none of these. I, my lord, have filed a writ petition before the Delhi High Court challenging that order, my lord. Please come to, my lord, 723. The rejection of my FDI, I have challenged it, matter is pending before the Delhi High Court. It is pending, my lord. In the meanwhile, my lord, they have issued a letter. Metro has issued a letter. Page 699. Sorry, my lord, I owe an apology. My lord, they have issued a letter stating that they will terminate, my lord, my contract. Therefore, I am before your lordship. My lord, I have given my investment, my lord, into India. My lords get that at, my lord, running pages, which I have, my lord, placed before your lordship. At, my lord, running pages 494, 499, my lord, 494, 490, my lord, 100 crores I have already brought in, admittedly. Now, my lord, 372 crores worth of bank guarantee I have given. They are terminating and, my lord, seeking to, my lord, invoke it. Therefore, I am before your lordship. Especially
bank guarantee how much? Bank guarantee what?
372 crores, my lord.
And it is valid.
Already invested.
It is alive till what? It is.
It is alive, my lord. My lord, I keep it alive, my lord. It is alive now, and I'll keep it alive, my lord, as long as your lordship, my lord, matter is seized off by your lordship, my lord.
Okay. So we'll restrain them for the time being.
All right.
Please,
my lord, and your lordship may impose a condition on me that I must keep it alive as long as this petition is pending, my lord, before my lords.
Yes. Who appears for
respondent? I appear for respondent number 1.
Yes.
Yes. The contract was of supply of 34 train sets by the petition company. And this contract commenced on 9th of December 2019. And even after 2 years, they have not supplied anything. They have not performed any of the key dates. And therefore, we issued a notice calling upon them to take up the work seriously. We still have not taken any decision to terminate the contract. We have said that we may take steps in that regard. We have not stated anywhere that we are going to enforce the bank guarantee. In none of the communication is it have stated that. We said that it will entitle us to take action in accordance with clause 13.2.1. And if we decide,
shall we say that you are making a statement that respondent number 1 does not, as of now, does not propose to invoke the bank guarantee, and you file objections? You file objections to this as you are taking your statement on record.
Because we are not sought to terminate the contract. We had to issue a notice, 14-day notice.
Fine. This is the senior counsel for the petitioner. Harish NS Learned Counsel appears on NM Learned Counsel appears on behalf of respondent number 1, heard on the question of admission as well as say issue notice. Notice on behalf of respondent number 1 is accepted by Mr. So-and-so. Then say heard on the question of admission IS so-and-so. Learned Counsel for respondent number 1 submits that the petitioner was awarded the contract of supply of 34 train sets. It is further submitted that as of now, the respondent number 1 has neither taken a decision to terminate the contract nor it intends to encash the bank guarantee furnished by the petitioner. Full stop.
As of date.
As of now, we have said Learned Counsel for respondent number 1. The aforesaid statement is taken on record. Learned Counsel for respondent number 1. How much time do you need for filing objections?
4 weeks, I think.
Waiver is granted 4 weeks time to enable him to file objections. This form, whatever the 4 weeks. 28 February, Mr.
Please, madam.
28 February 2022.
Please, my lords. My lords, I have a submission. I do not want to press prayer A, my lords, where I have challenged the validity. As other connected matters are pending before the learned single judge, my lords. Kindly, my prayer may be considered. Prayer A, my lords. which my lords would find it at page 16, my lords, 16, in page 16.
The next counsel for the petitioner states that he seeks to withdraw the challenge to the ordinance dated 29/3/2019 contained in annexure AC. Full stop. The aforesaid prayer is permitted to be withdrawn. Let the matter be listed before the appropriate bench as per roster.
Grateful.
Petitioner
appear for respondent 3 months, 2 months.
MBBS degree holder, lords.
I appear behalf of respondent. I appear behalf of respondent 2, my lord. NK Ramesh, behalf of NK Ramesh.
You are appearing, right?
Yes, my lord.
Yes.
Please. Lord, petitioner, lord, is an MBBS degree holder. Lord, she had filed an application, lord, in this NEET PG, lord, admission. But if lords may kindly, lord, turn to lord page 19 is my application. Lord, on filing of my application, lord, I had also submitted, lord, my certificate, that is caste certificate, which shows that I am a Christian belonging to lord category 3B. Lord, that certificate is at annexure C, page 17. Lord.
Category 3B.
Yes, Lord, category 3B. Lord. Page 17, Lord, should get it. Which is an income and caste certificate. Page 17, annexure C.
Yes.
The last but one paragraph, Lord, in the certificate mentions, Lord, I belong to caste Christian of category 3B.
All right.
Lord, but I was required to not appear for, Lord, the verification on 19th, Lord, as per the calendar of events, Lord, issued by the respondent. Accordingly, Lord, I appeared before them on 19th. Lord, at page 27, Lord, is their verification slip. Page 27, annexure H. Page 27. Serial number 4, Lord, should get it, Lord. They have said that my certificate, Lord, is incorrect. They asked me to, Lord, again obtain a certificate, Lord, from the Tahsildar and not furnish it to them. Lord, I immediately on the very same day on page 29, Lord, should turn to. Page 29, Lord. Annexure J, Lord. On the very same day, that is on 9th, Lord, to get the date on the top, not on the right hand side of the top. 19th was my verification. On the very same day, I made an application, Lord, before the Tahsildar, but asking them not to furnish, Lord, this minority certificate, Lord, which the second respondent was asking for. Lord, kindly turn to page 32, Lord, annexure K. Lord, on 21/1/2022, this certificate, Lord, was, Lord, issued. But what happened was 21st, Lord, the Tahsildar's office, Lord, there was a problem with, Lord, the server. Although, Lord, everything was ready, Lord, because, Lord, the thumb impression of the Tahsildar was not being taken online, Lord, this certificate was not issued to me on 21st. Lord, Tahsildar, in fact, asked me to go and speak, Lord, to the KE authority, saying that it is ready. The acknowledgement also is there, but, Lord, they refused to take it, Lord. Ultimately, I got this certificate, Lord, on 24th, because, Lord, 22nd is a holiday, Lord, it's a Saturday. 23rd, of course, is Sunday. Therefore, I got it only on 24th. But when I went and approached them on 24th, Lord, they have refused to, Lord, consider it, saying that it's already over, time has already lapsed. We cannot consider this.
What was the time over?
Lord, time according to them, Lord, gets over, Lord, on 21st. Sorry, 22nd, Lord, 22nd.
Where is that calendar of events?
Annexure F, Lord, page 22, Lord, should be. Serial number 5, Lord. Verification of documents at KEA Malleshwaram, Bangalore, 17/1/2022 to 22/1/2022. Lord, we have to make an option entry, Lord, which is at serial number 7, as to, Lord, which college you would want to select. Lord, that has now been extended at page 23
Ended up to. But that period blood has ended. Now blood, the publication blood of this mock interview, mock blood trial with regard to selection at page 23 blood should get it. But that publication blood is going to be done now. Page 23 blood, this notification is dated 25/1/2022. But let's see the second blood. I'm sorry. What publication of mock allotment results? Yes, Lord. So have you given an option entry? No, I have given an option, but not I cannot give an option insofar as not the minority blood college is concerned, because they have not accepted my minority certificate. All that they have to do blood is accept my minority certificate. I am not allow me blood to select not a college in a minority institution. My category does not change. Lord, only defect was the certificate was not made available, Lord, within the time frame. That is all. Yes. What do you say,
my lord? Kindly see Annex E, my lord, or application, my lord, wherein she what she has produced is caste and income certificate in Annex C, my lord, page number 17, my lord. In our application.
That's why you did not accept her certificate and you asked her to produce the
minority certificate
issued by Tehsildar.
Yes, my lord.
She has produced the certificate by Tehsildar. That is in order.
That is in order, my lord. After the date of
that's the only issue.
Verification of the document, she has produced, my lord. Our date was on 19th, my lord. Kindly see serial number 4, my lord. Religious minority certificate issued by the concerned Tahsildar of Karnataka. Where she has not produced, my lord.
Therefore, what for?
My lord, it's squarely covered by the decision of this honorable court, my lord. Honorable division bench, my lord. Number may I give?
No. Which serial number 4 you read? Which page? Without you did.
Sorry, my lord. Sorry, my lord. Page number 27, my lord. Sorry, my lord. 27, my lord. 3 is the caste and income. 3 serial number 3 is caste certificate by concerned Tahsildar, my lord. Serial number 4. Serial number 4 is.
What is the division bench decision?
My lord, it's in 36912 of 2017, my lord. I am
36912. You only have one copy.
My lord, I will produce, if my lord permits, at 2:30. I will, if it may be taken up, I will produce before the court, my lord. Squarely covers, my lord. Para 5, my lord. May I read?
When did she furnish the certificate in this case?
My lord, she has not furnished to us the certificate, my lord. As on the
earlier certificate.
Earlier certificate is only caste and income, my lord, not minority certificate.
When did she furnish this certificate?
19th, my lord. 19/1/2022, my lord. On the date of verification of the documents.
Then when did you ask her to submit the certificate?
She has not come before the KT to hand over any document, my lord. As on the date, it will be uploaded.
You asked her to submit a certificate right from Tehsildar.
Yes, my lord. As on the date, she should be.
He is not understanding what to do. So you please tell us when. They asked me to get the certificate on 19th itself after verification. 19th one they asked me. Yes, 19th they asked me to get the certificate. 19th, Lord, I apply for a copy. Lord, I have to run, Lord, from one department to the other. Lord, I process everything, Lord, and everything is ready. Got it on 24th January. Yes, Lord, it was physically delivered to me only on 24th because, Lord,
the entire thing was ready on 21st evening, and 22nd being a holiday, my lord, government offices, they did not give me a copy. Lord, the judgment which my learned friend is relying upon is completely different, Lord. Can I just proceed?
Yes, seeking to, it's a matter pertaining to change of category.
Yes, Lord, change of category. Here there is no change in category at all.
Yes, Mr. What you have to say, tell us now. So according to you, it is squarely covered. What else?
My lord, she should give the documents on 19th. The document, it will be uploaded in the KEA website, my lord. As on the date, mock-up round of first round is over, my lord.
Mock-up round is over?
Yes, documentation for first round, my lord.
What are you saying? Are you sure about what you are saying?
Yes, my lord. Kindly, for option entry, already it has been, we have received.
Mock-up round is over. Mock-up
Sorry,
round
my lord. For first round, my lord. Sorry, my lord. Sorry.
What first round?
First round of seat allotment, my lord. 10, my lord.
What?
May I? First round of seat allotment, my lord.
Don't make this sort of stray distinct statements without understanding what you are saying. What is over? You want to know what did you say? What is over?
My lord, may I, page number 22, annexure F, my lord. Kindly see, my lord. List of calendar of events, my lord. Serial number 8, my lord. Publication mock allotment results, my lord.
Yes.
It has happened today morning at 8 o'clock. It has been finished, my lord. That's what I am saying, my lord.
To say clearly, no.
Sorry, my lord.
Today morning.
Today morning at 8, my lord.
28th January.
Yes, my lord.
Sir.
Please.
Yes. What
can I just turn to page 23, my lord, for a moment? That was the original date. Page 20 on, if you not should turn to not the second entry, option entry by eligible candidates in order of preference, up to 9 a.m. 27/1. Publication of mock allotment results 27/1. Then next one, provision to change options, if any, by students, add or delete or modify or reorder or alter the options from 7 p.m. on 27/1/2022 to 29/1/2022. And then publication of the first round real allotment result is on 29/1/2022.
So you want this thing permission to change your option, right?
No, yes, but first they have to accept my certificate so that I'll be in a position, not in online, I'll be able to change my option. Seek for the minority institution. Otherwise, I'll not be able to do that unless they accept my minority certificate.
Why? Any explanation why you? I mean, it's required calendar of events or whatever requirement was clearly there is that you should produce a certificate from Tehsildar. Why you did not do so?
Not the certificate.
Any
I understand, Lord. Kindly see if my lord kindly turn to annexure C. That certificate also, my lord, says not that I belong to minority, is issued by the Tahsildar itself. Page 17, annexure C. Income and caste certificate, Lord. Can I persuade, Lord? So kindly see, Lord, the last but one line in that certificate. Lord, it says belongs to caste Christian of category 3B of backward class and certified by his annual income of so and so. Then kindly see the signature down below, Lord. Is by the Tahsildar.
This is why it was not accepted.
No, they saying that you have to bring a separate minority certificate. And that certificate, Lord, was thereafter issued.
My lord, may I make a submission, my lord? In the instructions itself, it has been given to them. They have to produce the minority certificate in that instance, my lord. They have to produce. It's a must, my lord, because it will open up Pandora box, my lord. Because there will be so many students who have not produced. They will. Who have not produced before us, my lord. They have not given the minority status, my lord. If this petitioner is allowed, my lord, similar kind of students may come before this court, my lord. That is my submission.
This court is open. It can be visited by anybody. We cannot prevent anybody from coming.
That's all, sir. Yes, ma'am.
Counsel for the petitioner. Like his name, learned government, additional government advocate, and then who's there, Mr. What's his name?
Sir, your name, sir?
Sandeep Par for NK Ramesh.
NK Ramesh. The question of admission, as well as interim leave. Yes. Yes. Sure. Yes. A degree in MBBS from Mangalore. Secured a degree of Bachelor of Medicine and Bachelor of Surgery in the year 2020. Good stop. The petitioner is a Christian and belongs to category 3 within bracket capital B, a religious minority community. Full stop. The petitioner appeared in NEET PG examination in 2021 and thereafter the petitioner submitted an application for admission to the postgraduate medical course for the year 2021-22 before the Karnataka Examination Authority. As per paragraph, as per the calendar of events, and as per the petitioner's rank, slot for verification of the documents was fixed for 19/1/2022. The petitioner appeared on 19/1/22 and submit the requisite document issued by the Tehsildar pertaining to income, pertaining to her income as well as her caste. The petitioner on 19/1/2022 itself was asked to furnish a separate caste certificate. Thereupon, the petitioner applied to the Tehsildar for furnishing a caste certificate on 19/1/2022 itself. A copy of the caste certificate caste certificate to the petitioner on 24th January 2022. The petition, however, the respondent number 2 did not accept the caste certificate furnished by the petitioner on the ground that the same has been produced by the petitioner belatedly. Full stop. Paragraph. Admittedly, the issue with regard to admittedly the fact that petitioner is a Christian and belongs to a minority community is not in dispute. Full stop. In other words, eligibility of the petitioner to apply for a minority seat is not in dispute. Full stop. It is pertinent to note that initially the certificate dated 14/8/2020, which was published by the petitioner, was also issued by Tehsildar and was in which it is stated that petitioner belongs to Christian caste and belongs to category Roman capital 3B. Full stop. On account of insistence of respondent number 2, the petitioner obtained a separate caste certificate and has produced it before the authorities immediately on receipt of the same on 24th January 2022. Full stop. Paragraph. Paragraph. Therefore, in the particular facts of the case, since the issue with regard to eligibility of the petitioner is not in dispute, we direct the respondent number 2 to accept the caste certificate of the petitioner and to permit her to select a college which is run by a minority. Then in the beginning you say, how much time do you need for filing objections, Mr.?
My lord, next week, my lord. Next week.
Praise for a week's time to enable him to file objections. Next on say 7th February 2020. Today,
I would be permitted to even modify not my seats. I will be permitted to modify the allotment.
You will be permitted to modify the options. The needless to state that the petitioner shall also be permitted to modify the options. Yes.
Great.
My lord, on submission, my lord, it may be uploaded, my lord.
Directed to intimate, my lord, the KEA so that, my lord,
If it may uploaded.
It will be uploaded, yes.
Great.
We'll sign it just now within 5-10 minutes. Don't worry.
Great.
Number 24.
In this matter, appear for the respondent. My lord, we are exploring the possibility of settlement, my lord. Final opportunity may kindly be granted. I also requested my learned friend on this. It's an error matter.
However, my lord, if I may request for a date to be fixed, my lords, please, because otherwise the developer will become unresponsive.
I'm responding.
Certainly pray for and are granted 2 weeks time by way of indulgence to enable them to explore the possibility of an amicable settlement. This on 9th of February 2021.
Obliged, my lord.
Grateful, my lord.
Petitions number 25.
Counsel for the appellant, my lords. Counsel for the appellant, my lords. My lords may kindly grant an adjournment in this matter as Mr. Shamsundar, my senior, is on his legs before the Supreme Court, my lords.
For adjournment, this after 2 weeks.
So grateful, my lords.
Case for adjournment on the ground that arguing counsel is not up.
26. Sri Joseph Anthony. Sri Rajendra, yes.
My lord, for the appellant in this matter.
I beg to appear for the respondent.
My lord, this matter is in fact covered by the New Tech promoters' decision, my lord. And in similar matters, your lordships was pleased to direct the appeal to be restored, subject to payment of the amount as directed by the appellate authority. My lords, this is order in RERA appeal number 9 of 2021, my lords.
File it.
Please, my lords, I'll file it. I'll file it along with the memo, my lord.
Monday.
Please, my lords.
The counsel for the appellant pays for short accommodation in order to enable her to place copy of the judgment passed by this court in RERA appeal number 9 of 21. Just on Monday, 31st January.
Great.
I appear on behalf of the advocate for the appellant. This is a developer's appeal under RERA on a very limited ground. June 2021, there was a hearing conducted by the tribunal.
The other side is not there. Passover, Mr. Joshi.
Next week, Passover or next week, my lord, there's an interim order that I also need to file a synopsis of documents. Next week would be more convenient.
Vijay Joshi, senior counsel for the appellant. None for respondent, awaiting appearance of learned counsel for respondents. Hearing of the appeal is deferred. Interim order granted on earlier occasions will continue this next week.
Grateful.
Number 28.
Appear on behalf of the advocate for the appellant. This too is a RERA appeal on a different issue of interest. This is ready for hearing if the other side is available.
I need some instructions, my lord. Can it be taken up next week, my lord?
How much time? Next week?
Yes, my lord.
Very well. Interim order to be extended.
Short accommodation to enable him to seek instructions.
Here also interim order to be extended, my lord.
Interim order. The content on the realization shall continue just next week.
Grateful.
Number 29. Lords, in this case, I appear for respondent, my lords. I seek a week's time, my lords, to file my counter to the application for stay, my lords.
Lord, I appeal for the petitioner's counsel, appellant's counsel.
They have a right to file a counter, right?
Let them file.
Mr. Siddharth Suman, learned counsel for the appellant, Mr. Who's the appellant? Samuel, learned counsel for respondent number 1. Petition granted. How much time?
Weeks time. 2 weeks, 2 weeks, madam.
To enable him to file objections to IA1 of 21.
Continuing D group, 730, Sri Ramakrishna Iyer, government advocate.
Yes.
Ramakrishna Iyer.
Mr. Yes, please.
730.
I appeal for the petitioner advocate, madam. Petitioner advocate passed away on 25th.
Oh.
Mr. M. Ramakrishna has passed away on 25th. I will have to inform the client and seek in.
So and so, learned counsel for the petitioner says for adjournment. Arguing counsel Mr. Ramakrishna M. has passed away on 25th January 2022. Just after 2 weeks.
3 weeks, madam.
Your name, sir?
What's your name?
Satish. R. Satish.
R. Satish.
Number 31. The Ansi Zulfikar Rahman Nisar Ahmad.
I appear for the petitioner, your lordship. I am not keeping very well. I pray for at least a week's time, your lordship may please grant.
Pay for adjournment on the ground that is done and will this after 1 week.
Much obliged.
Final disposal. Final disposal. Number 32.
Lord, I am for the respondent in this matter.
I appear for the appellant.
Lord, it was brought to your lordship's notice on the last day. The moratorium, Lord, has been imposed by the NCLT in a connected matter, Lord. As such, the same thing is still continuing even today also. Lord, due to COVID and things like that, my Lord, an application for extension, seeking extension of the moratorium period has been sought and no orders, my Lord, has been passed by the NCLT, my Lord. So that is where, my Lord, I want to place this on record before your lordships. Lord, on 18/3/2020, it was brought to your lordships that on 7/2/2020, my Lord, moratorium has been imposed.
How much time, Mr.? How much time should be deferred?
My Lord, problem now, my Lord, is that an application seeking for extension is filed before the NCLT and no orders are being passed by NCLT, my Lord.
My Lord,
now that Supreme Court, my Lord, has also extended time.
2 or 3 months. I think my lords may defer it by about 2 or 3 months.
Like in the light of observations made in the order dated 18 March 2021, hearing of the appeal is deferred by 3 months.
Please, my Lord. Much obliged.
Final hearing, number 33. Srimati Mrinalini R.
My lords, I appear for the respondent in this matter, my lords. I pray for 3 weeks' time, my lord.
Respondent.
Respondent number 1, my lord.
What's your name?
My lord, my senior's name is Mr. S. Annamalai may be shown, my lord.
So what is it? What is petition of 2013? And
Yes,
where is time? Tell us what is it about?
My lord, it's a disciplinary proceedings under the Chartered Accountants Act, my lord, instituted against the respondent number 1.
So your client is not in a hurry. 8 years.
My lord.
This is of 2013.
Yes, my lord.
9 years. How
Yes, my lord.
long
I'll
you
prepare.
want to remain pending?
Yes, my lord. 3 weeks time, my lord. Next time we'll argue, my lord.
No, this is no adjournment, right? Be very clear.
Yes, my lord.
This is all 9 years old. In a casual manner, what is this? Why? What have you been doing for 9 years?
Yes, my lord.
2 weeks time is granted. What's your
Obliged,
name?
my lord.
What's your
Madhusudan, my
name?
lord. Madhusudan, my lord.
Learned Counsel for Respondent. Case warrant is granted. 2 weeks time by way of last indulgence to enable him to argue the matter. It is made clear that no further adjournment shall be granted at the instance of respondent on the next date of hearing. Just after 2 weeks.
Obliged, my lord.
Number 34, Sri Abhishek Malipati, Sri Ayappa, Sri N. Ketty, Government Advocate, Sri K. N. Subbareddy, Sri V. Ravishankar.
My lords, I appear for the petitioner, my lords. My lords, in this petition, I've filed a memo for withdrawal, my lords, but on the last occasion, Learned Counsel, my lords, Learned Counsel for the respondent said that his IA has to be considered. My lords, I'm not aware which IA, my lords, they are pressing now, because all fees has been, my lords, paid back pursuant to directions issued by this honorable court. Nothing further survives, my lords, for consideration in this petition.
I appear for the respondent, my lords. The submission with regard to the withdrawal of the matter has been considered by this honorable court in WP number 4811 of 2016 on order dated 20th March 2017. And the withdrawal has been said that only after deciding the merits of the matter in 41899, it shall be considered. The petitioner counsel, having very well known about this fact, is making submissions again and again about the withdrawal of the matter. And the lordships on order dated 20th March have detailedly noted why the matter cannot be withdrawn. And I've also said that there are various other factors which has to be considered before deciding the matter, my lords.
Subsequent to passing of that order, my lords, fees was deposited before this honorable court. Students have approached, my lords, the registry and withdrawn the amount, my lords. If there is any other amount that they are insisting on, my lords, I'm not aware, my lords. That is why I'm asking.
My lords, kindly leave, my lords. May I take my lords' attention to the order dated 23/2017.
No, we don't know. None of you have told us what is the matter about. We are just what he is trying to tell us that your grievance probably stands redressed. Is it correct or not? Not correct. What he is trying to say.
This petition was filed by the institution, my lords, against the order of the MCI, not granting permission, my lords, where interim orders were granted, my lords, granting permission to admit students. Subsequently, my lords, it was taken up before the Supreme Court. Supreme Court had set aside that order, where, my lords, before the Supreme Court, the students appeared and said they don't want to continue in this institution. Hence, my lords, arrangements were made, my lords, for the students.
Which order seems referring to Mr. Patil?
My lords, in my writ petition, my lords, the first writ petition is by the institution, my lords.
So which order is referring to where he says that your IA has been dealt with and it has been said it can't be withdrawn?
In a petition filed by the students, my lords, that is not pending anymore, my lords, but it is part of the records in this writ petition.
No, in your petition 41899, there is no such order.
No, my lords. So, my lords, in this writ petition itself, subsequently, my lords, this honorable court having directed me to, my lords, return the fees. The fees was in fact deposited before this honorable court, my lords, and withdrawn also.
Yes, Mr. What is your objection to withdrawal?
Lord, I'll just explain the matter in a very short.
No, order. You are referring to some order.
Yes, my lords. That is the order dated 23/2017, passed in WP number 4611 of 2016.
That is in his petition we are asking.
My lords, the same, my lords, because all these matters were connected together. I'll just explain, my lords. Writ petition number 41899 of 2015 was filed by the college questioning the order passed by the MCA for not renewing the.
Once you have referred the fact, complete it. You said refer to an order dated 20th March 2017 in which writ petition?
4611, my lords. Writ petition number 4611.
Of which year?
Of 2016, my lords. It is connected to the main matter itself here. 34.1 is the matter connected.
Should you not be complete? I mean, should you not mention the year? How do we know
My
which year?
apologies, my lord. Since it is connected with the same matter,
So there is no connected thing.
my lords, 34.1 is that one, my lords.
Yes. What is it? 4611. What is the order? Read.
My lords, page number 58, my lords, para 22. Order dated 23/2017. The final order in 4611 of 2016 writ petition, my lords. Para number 22, page 58.
Tell us what is the subject matter?
Yes, my lords. Para 28.
Just a minute. What is, please, if you can't proceed and can't tell the court, we have to ask. So, what is the subject matter of WP, this writ petition 41899? What they have challenged?
Well, I'm for the petition.
No, let him say. Please, we'll come to you.
Please.
What they have challenged?
My lords, the college had filed the writ petition number 41899 in 2015. My lords, college had preferred that writ petition where the MCA had challenged the approval given to the petitioner institution 41899 for the year 2015-16.
What is under challenge in this writ petition, Mr.?
My lords, in writ petition number 41899 of 2015,
yes,
the college had challenged the MCA's order of cancellation of the approval given for the academic year 2015-16.
Order dated?
My lords.
This is not the writ petition, Mr. 41899 we want. You are giving us something else. And that first matter.
Order dated 23/9/2015, my lords, was questioned by the college.
2015.
2015, my lords.
What is that order?
Lords, that order was to.
Which page?
That petition is with Mr. Abhishek Mali Patel is representing the petition on that matter, my lords. I don't have the petition copy. That one.
We have got Mr. K 126. Whereas Sri Devi Institute of Medical Sciences has applied for renewal of admission. Third batch. Which course permission was refused? Mr. Patil.
Malods, MBBS Malods, third batch Malods, the entire institution.
So what happened to this order then?
Malods, this year, Malods, we have not made, Malods, the interim order which was granted by this Honorable Court in this writ petition to admit students, Malods, was challenged by MCI before the Supreme Court.
When was this interim order granted?
Apologize, Malods, I don't have the date, Malods. At the initial stage itself, Malods, interim order was granted. Malods, it was taken up before the Honorable Supreme Court by
28/9/2015, my lords. The interim order was granted.
I'll make it short, Malods, so that learned counsel could address his issue, Malods, because there's only one issue left, Malods, no other issues left for your lordship's consideration now. my lords, because subsequently, my lords, since the badges.
What happened to Supreme Court when this order was set aside by Supreme Court?
Lord, Supreme Court on 16/10/2015, my lords, had kept the order of the interim order passed by the Honorable Court in abeyance, my lords, and kept the admissions made with respect to these petitions have also been kept in abeyance on 16/10/2015 itself. That is after 15 days from the date of the interim order.
No admission for academic session 2015-16 could be made, right?
It was kept in abeyance, my lords.
So
yes, my lords. 50, but what has happened in the meanwhile was 60 common.
No. What do you mean to say that? Supposing if we decide the petition, dispose of the petition today, they will give admission with effect from 2015-16.
No, my lords. The question of admission. The question of admission has become infectious, my lords. The question of admission has become infectious in these matters. The only thing survives in the petition. Please, my lords.
What is we are trying to understand one by one.
Please.
What is the other petition?
My lords, after the order of the Supreme Court, my lords, the students approached the Supreme Court on 21/1/2016, my lords. The Supreme Court said that the application may be moved before the High Court with regard to the admission as well as the refund. Apologies, my lords.
Counsel, please see the prayer clause in this petition. 41899. What is the prayer clause? First is writ of certiorari for quashing the order dated 23/9/2015, right? Then second is respondents to consider petitioner scheme for renewal of permission that has now infructuous by flux of time. Third is writ of mandamus or any other writ declaring the petitioner is entitled to renewal of permission, again infructuous, right? Fourth is issue a writ or direction directing respondent number 3 and 4 to draw an additional seat matrix and carry out selection to the available seats for the current year. This relief has become infructuous. Now, mandamus deems fit any other relief. So what survives in this petition?
My lords, I'll just explain.
Why he should not be permitted to be here? Please understand, he has not taken benefit of any interim order. Though an interim order was granted, that was subsequently stayed by the set aside by Supreme Court. The fact remains that in pursuance of the interim order, no admissions have been made for academic session 2015-16, and this is you do whatever you want to do. What is there in this petition?
No, my lord.
How can you prevent?
This court on an earlier occasion, my lords, considered all these aspects elaborately, my lords, and had passed an order on 23/2017.
We are asking you tell us what survived. We have told
yes,
you.
My lords. What survived this, my lords?
Mister, please understand, we are not sitting here to convince you. Despite that, in order to bring clarity, we told you what are the reliefs. You have just now agreed that nothing survives for consideration.
I'll just explain one.
Please understand, if you have any right, do whatever you want to feel like. I mean, how can he be compelled to prosecute? Even if he doesn't want to withdraw, we will say that nothing survives. It has become infructuous.
My humble submission, my lords, page number 58 in the order dated 23/2017 maybe looked once, my lords.
Yes. Which 23/8?
My lords, in order, WP number 4611 of 2016, order dated 23/2017, my lords, maybe look, my lords. 23/2017, my lords.
It is some student's petition.
Please, my lords, it is a student's petition.
We will deal with it.
My lords, the issues are interlinked with these matters, my lords. That's why I'm making your lordship's attention to this page number 58, para 22, my lords, where it has been clearly stated about the withdrawal. Para 22. May I read, my lords? Mr. Abhishek Malipatil, learned counsel for the college, submits that this college may be permitted to withdraw WP number so and so For such purpose, he tendered a memo containing that the petitions have become infectious, and he also submitted the respective academic year 2015-16 is over, and hence he may be permitted to withdraw these petitions. At first, we find that if the petitioners are desirous to withdraw the petitions, the court may leniently grant permission. However, it appears that the present matter is not of such kind. The aspect of withdrawal can be considered simpliciter without considering the consequences thereof. As observed earlier, after filing the present petitions on 28/9/2015, the interim order came to be passed by this court, whereby the college was permitted to grant provisional permission to the petitioners to conduct the course for the academic year 2015, subject to further orders as may be passed by this court. And the college was also permitted to admit the students, of course, with a clarification that the admissions are subject to the result of these petitions. The fact remains that pursuant to the aforesaid interim order dated 28/9/2015 passed by the court.
That's the thing. We understand basically.
I'll just conclude my submissions, my lords. I'll just conclude, my lords, that the same paragraph, my lords, the fees were collected by the college institution, and when they were prosecuting the studies, in the proceedings before the apex court, the aforesaid order was kept in abeyance by the apex court. Prima facie, it can be said that the question of collection of fees based on the admission and subsequent non-continuation of the studies of the students concerned have all arisen from the orders of the court dated 28/9/2015. It is hardly required to be stated that no litigant should be allowed to earn any premium on account of the orders passed by.
So just a minute, whether fees has been returned to 60 students.
That is what, my lord. The college had given a calculation of 5,08,000 for each student. In the same order, my lords, page number 52 may be seen once, my lords. 52, there's a tabular column where the institution has said what is the amount of fees collected from each student. It states about 5,04,000 for each student, and out of this 5,04,000 has been deposited before the registry, my lords, and 4,33,000 has been refunded by each of the student. I had filed an application, my lords, for hostel fees to refund the hostel fees, my lords. That also has been considered in this order on 23/2017, wherein
what amount has to be paid to you? You tell us, no?
My lords, the balance is, please, one minute.
That was Mr. Mali Patil is saying, that if we have paid the amount, if they want something more, please tell us. Simple, no? Instead of doing all this.
Balance 1,10,000 has to be paid, my lords, for each student. 1,10,000, my lords.
Where from you get it? 1,10,000. You have to file an application, Mr. Giving the particulars.
We have filed an application, my lords. IA number 2 of 18 has been filed.
Which case you have filed? In your petition?
No, my lords, because these petitions were all again connected, my lords. This order could be read once, my lords. This order dated 23/2017 could be read once, my lords. The entire controversy could be understood in a very clarified manner, because all the issues.
I will tell you, you have not understood the controversy despite representing the respondents for several years. We are telling you the controversy is, the principle of law is that no litigant should be allowed to take advantage of an interim order passed by this court. This is the principle of law. In compliance of an interim order, the management had admitted 60 students to 2015-16 course and had recovered fee from them. We understand that fee needs to be refunded to the students, and that benefit he cannot seek of an interim order. The parties have to be placed in a position which they were prior to approaching this court. It is simple. There is nothing to be read about, nothing to be understood. You should have told us in the first place in 3 sentences, Mr. Counsel.
My apologies, my lords. I was assisting the court, my lords, with regard to the clarity of
why we are telling you, why? Because you are a young lawyer. These are the opportunities to learn. You should have told us in the first sentence that, sir, the issue is rendered academic. However, petitioner cannot be allowed to take advantage of an interim order. We have not been given the full refund of fee. This is what has been paid to us. This is what balance remains. This is what I have IA filed. Instead of it, you are taking us that order, this order, there, here. He cannot be permitted.
My lords, I'll just.
Mr. Patil. So how much amount is according to you due? Now we have to adjudicate this.
My lords, I have not received.
Have
the
you
IA
filed
memo.
objections to the IA?
No, my lords, I have not received the IA, my lords, because there's some office
So
objection.
then that's the end. What is your IA number?
My lords, IA number 2 of 17 for direction.
Learned counsel, you are appearing for which respondent?
I appear for respondent number 5 to 86, my lords.
Learned counsel for respondent 5 to 86 undertakes to supply copy of IA 2 of 2017 to learned counsel for the petitioner within 3 days. Who praise warrant is granted? How much time?
My lords, 2 weeks time, my lords, I'll take instructions.
2 weeks time.
Thereafter.
Enable him to seek instructions and to file objections.
Please.
Right, my lords.
35, Srimati Sumana Nagana, Sri
I'm appearing for the.
C.S. Annamalai.
I appear for the petitioner, my lord. My lord, I apologize, my lord. It may be taken up next week. We'll file our synopsis as well, my lord. I request for one accommodation.
This next week.
My lord, may I make a submission, my lord. My lord, in this matter, I appear for the respondent.
Get it uploaded. Yes, Mr.
My lord, in serial number 35, my lord, I've entered appearance for the second respondent. My name may be shown, my lord, Shanti Bhushan AST.
Office is directed to reflect the name of Mr. Shanti Bhushan.
Please.
As counsel for respondent number 2.
Please, my lord.
Respondent number 2. List in the next week.
Grateful.
Number 36, Srimati Tanvi Rajkumar, Sri K.B. Arvind.
May I please, your lordship?
My lords, I request for a short pass over, my lords. My senior is on his legs before Kotal 1. My lords, he is ready, my lords. Any pass over, my lords?
Mr.
I'll leave to your lordships. I'm here.
So, number 37, Sri M.A. Sebastian, Government Advocate, Sri Ashok Nair, P.S.
I appear for the
Malapati,
petitioner, please, my lord.
P.R. Mahendra.
I appear for the petitioner. This is the case wherein the admission was given to the petitioner without the.
This is the case where petitioner is prosecuting wrong remedy. I remember, yes. We asked the counsel for management to seek instructions as to how much amount they can refund.
Yes, my lord. Yes,
who appeared correspondent?
Sri Ashok Nair, Sri P.S. Malapati, Sri P.R. Mahendra.
Tell him nobody is there.
Malapati was there in the 34th matter. He was there. Yes.
My lords, I appear, my lords, learned counsel, Mr. Mahendra, my lords, appears for the institution. We have issued NOC, my lords, and learned counsel, who is already on record, my lords, appears.
He's not. Tell him he's not there.
Sir, he is not there, sir. Mahendra.
Sure.
Pass over. 38, Sri Amar Vijay Kumar, Sri S.D. Chokar, Sri Lakshmi Steve.
Petitioner, my lord. The petition is filed against the order passed by the respondent number 1, my lord, overseeing committee. Wherein
Lakshmi Steve. Pass over. Number 39, Sri Shishibhushan D.S.
I represent the petitioners in this case, my lords.
I appear.
Request for a week's time accommodation in this case, my lords.
I appear for the respondent number 2.
Can I request for a week's time, my lords? I shall get ready.
I appear for the respondent number 2.
I represent the petitioner, my lords.
That's the problem. Appearance is fine. It should you argue, Mr.
I appear for the respondent.
I represent the
No,
petitioners.
we have heard it for the fourth time, Mr. We can now
Sorry,
tell
madam.
who is appearing for whom. We are trying
Sorry.
to ascertain about the matter. Appearance is fine. Fourth time you have told us that you
Sorry.
are appearing for petitioner, he is appearing for respondent. That's all right. We are trying to understand what is the matter and what is the order. Yes.
My lords, order is, my lords, at the translated version is at internal page 55, annexure H, my lords. A complaint was filed by the petitioner stating that the respondent number 2 has occupied the forest land and a complaint was filed. The impugned order has been passed by the annexure H. Translated version is at internal page 55, my lords, wherein the complaint has been dismissed. Internal page 63, my lords. I am the complainant before the land grabbing prohibition special court.
Complaint has been dismissed.
It has been dismissed as against which the present writ petition has been filed.
Is it your land?
My lords, our contention, it is a government land, it's a forest land. By colluding with the authorities, the documents have been created.
So you are entitled to allotment of forest land, right? If
The
it's a forest land,
respondent
then
number
you have a
occupying-
right to occupy it. That's
No,
why
respondent-
respondent should be evicted and the possession of that forest land should be given to you. This is the case.
No, it's not. I am not seeking for granting it to me, my lords. I state that it has to be taken back by the government. My lords may kindly take my complaint, which is at
You are
annexure.
a public spirited individual, right? Huh? You are a public spirited individual who wants to safeguard the public property, right?
May I take my lords to annexure F, my lords, internal page 33. My lords may kindly take internal page 35, column number 10 prayer. It is prayed that the above land be declared as the property of the state of Karnataka and the respondent shall be evicted from.
No, we have understood. You are a public spirited individual who wants to safeguard the public property. Fine. What about the case? Yes. Why do you say it's a forest land? What is your?
No document produced to that effect. Your argument kindly see. I am the person to respond.
No, let him argue. Let him.
Okay, sorry, man. Sorry, man. I'm sorry.
I'm sorry, my lords.
Please.
My lords, I am the petitioner, my lords. My lords, it is for that reason I prayed for a week's time, my lords, because I will argue on the next week, my lords. I shall just go through certain things. I'm sorry, my lords, for seeking.
No adjournment, further adjournment.
Number 40, Sri M. Narayan Bhatt.
My lord, I appear for the petitioner, my lord.
My
lord, I pray for 4 weeks time, my lord. I am tested positive for COVID.
For adjournment, just after 4 weeks.
Adjournment.
41.
We wish you a speedy recovery, Mr.
Madam, for respondent
It
number
won't
1,
take 4 weeks.
due to COVID positive, my senior is unable to appear today.
My lord, I will record.
I praise your honor.
Just after 3 weeks.
42, Sri K. Subbareddy, Sri G.S. Bhatt, Sri M.K. Ramesh.
I appear for respondent 3, my lord.
My lords, I appear for respondent number 2. I pray for 2 weeks of time as there is a COVID outbreak in our office, my lords. Even senior is not well.
For the petition on this matter, my lords, a date may be fixed, my lords. Matter where lordships have heard.
On the ground that counsel is arguing counsel is unwell. List on 8th February. 8th February.
Please.
43, Sri P.V. Appaya, Sri Ranjan Kumar.
Appear for the appellant in this matter, my lord.
Yes.
The issue involved in this appeal, my lord, is there was a transaction for the purchase of an apartment.
Who appears for respondent?
I am for the respondent number 1 appearing for the real estate regulatory authority, my lord. Respondent number 1. But contesting respondent is the respondent number 2, my lord.
Where is he?
Sri K. Ranjan Kumar.
Not there, Mr. Apaya. Ranjan Kumar. We'll take it up next week.
Please, my lord.
May I request week after next, my lord, because next week I have some domestic engagement.
The learned counsel for the appellant, Mr. Rajshekar K. Learned counsel, respondent number 2. Waiting appearance of learned counsel for respondent number 2. Hearing of the is on 9th February.
Very well, my lord.
44. Srimati Sonali Senge. Sri K.V. Arvind.
My lords, item 44, may I request for a passover?
You are ready?
My lords, item 44, I appear. My lords, the senior counsel is leading me in the matter. My lords, may I request for a passover, my lords?
You are ready, no?
Yes, my lords. My lords, just requesting for a short passover if possible.
Yes.
Yeah. 45. Sri Mahesh here.
My lord, I
petitioner.
appeal for the respondent number 4, my lord. I'm praying for a short accommodation as my senior is tested positive, my lord. Kindly have it on 1st of February.
Very well, my lord. But in the meanwhile, may I, my lord? May I, my lord? In the meanwhile, I submitted a memo with order passed by this honorable court in MFA, my lord. That may be kindly considered, my lord.
Yes, yes.
Please.
Mahesh for the appellant. Write her name. What's your name, madam?
Tukanksha, my lord.
Learned counsel submits that the arguing counsel is unwell list on 1st February 2020.
Grateful.
Passover matters. Number 36.
I appear for the appellant.
Kumar.
I appear for respondents, my lord.
Sir, ready?
Please, my lord.
We can conclude it before 1:30.
I think we can conclude it. I think short matter.
Yes.
My lord, there are two connected appeals. ITA 1000 of 2017 pertains to assessment year 2007-8.
Right. 2000?
7-8.
ITA 1000.
1000.
1000 pertains to
AY assessment year 2007-8. And the other appeal, ITA 1001 of 2017 pertains to assessment year 2008-9. My lord, both the appeals involve the issue of disallowance under section 14A of the Income Tax Act. Now, at the time I filed the appeal, my lords, I had raised three questions. If my lords take ITA 1000 of 2017 first, and turn to page, if my lords could kindly turn to page 11, I had raised three questions, but what was admitted is only question number 2 and 3.
B and C, yes.
That's because question 1, which I raised at the time of filing the appeal, at the time of admission itself, stood covered by the decision of the Honorable Supreme Court in the case of Maxop, which my learned friend has produced today. Therefore, that first question was not admitted. It was covered against the SSC, therefore, the first question was not admitted. Only second and third questions in ITA 1000 of 2017 were admitted. And in ITA 1001, two questions were raised. The first question was not admitted. Only the second question was admitted. My lords have that. So now the issue, my lord, is confined to because if my lords may recall, the Honorable Supreme Court in the case of SR has said that section 14A, subsection 2 and 3, read with section rule 8D, applies prospectively and applies only from assessment year 2008-9. Now, that judgment of the Honorable Supreme Court in SR, my lord, came after we filed this appeal. Therefore, today I have filed a memo, Your Lordship, for Your Lordships to consider framing an additional question because the applicability of section 14A goes to the root of the matter as far as assessment year 2007-8 is concerned.
The additional question.
I have filed a memo, my lord, today requesting Your Lordships to frame an additional question that for the assessment year 2007-8, that is in the first appeal, the no disallowance under section 14A can be made because rule 8D has been declared by the Honorable Supreme Court to apply prospectively from assessment year 2008-9. My lords have that memo?
Yes, sir. What for Mr. Arvind?
So if this question is answered in favor of the SC, my lord, following SR, which Your Lordships have followed in other cases as well, up to 2007-8, then the other questions in this appeal need not be gone into.
Yes. What do you say, Mr. Arvind?
My lord, my full submission, my lord, is no doubt, my lord, the Honorable Supreme Court, my lord, has held. My lord, the subsection 2 of 14A, my lord, provides for, my lord, making a disallowance of an estimation. My lord, the prescribed formula, my lord, was prescribed, my lord, under rule 8D, my lord, under the rules. My lord, that rule, my lord, was applied, my lord, prior to, my lord, for the prior assessment year, saying that, my lord, it is a procedural one. The Honorable Supreme Court, my lord, has held that, my lord, rule 8D formula, my lord, will come into effect from 8-9 onwards. It is not applicable. My lord, as on that day, my lord, now by virtue of, my lord, that is, my lord, that legal position, my lord, was laid down, my lord, in 2018 by the Honorable Supreme Court. My lord, that will not take away, my lord, the requirement or, my lord, the empowerment of the assessing officer, my lord, for making an estimation of disallowance, my lord, in respect of expenses which has been incurred, my lord, in relation to earning of exempt income under 14A. My lord, because, my lord, the assessing officer, my lord, has applied, my lord, rule 8, my lord, 8D, which has been held, my lord, by the Honorable Supreme Court to be prospective. In view of, my lord, that fresh declaration of law, my lord, dehars, my lord, that power, my lord, the 14A, my lord, needs to be re-examined and requantification has to be done. Because the first contention, my lord, at the initial stage, what the assessing took up a contention is, my intention, my lord, is not, investment is not to earn dividend. It is a strategic investment that is to hold control, my lord, in the company. My lord, that has been turned down, my lord, by the Honorable Supreme Court, my lord, in Maxup, which is a subsequent judgment. In view of that, my submission, my lord, is dehars, my lord, application of formula, my lord, under 14A2, my lord, the requantification, my lord, has to be held, my lord, without applying the formula. But the Honorable Supreme Court, my lord, has not ruled out, my lord, the estimation is concerned. And Your Lordships have held that, my lord, it is not a merely an automatic, but it has to be, my lord, estimated how, my lord, the expenditure has been incurred in relation to the exempt income. My lord, that exercise has not been undertaken. Hence, my lord, my submission, the matter, my lord, on the additional question is concerned, my lord, has to be, my lord, has to be remanded back, my lord, to apply, my lord, 14A2. Without a formula, my lord, it needs to be re-estimated is my submission.
May I submit, my lord? I'll just then the matter requires a little explanation with reference to the judgment of the Honorable Supreme Court in the case of SR. Since my learned friend is saying that the matter requires remand, which I oppose, because after the once the Honorable Supreme Court says that Rule 8D applies prospectively, then the question of any estimation before 2008-9 doesn't come. Because even what my learned friend says, 14A2 says estimation has to be done as prescribed. That prescription came by Rule 8D only with effect from 2008-9. Therefore, my lord, I'll take Your Lordships through the provisions. If my lords, May I submit, Malad? If Malads will kindly take section 14A for a moment. Section 14 capital A, Malad, it's at page 1.205.
Yes.
Expenditure incurred in relation to income not includable in total income. Now, kindly see, my lord, this provision 14A1 was introduced with effect from 2001. That your lordships will get at, yes. So the subsection 1 says, for the purpose of computing the total income under this chapter, no deduction shall be allowed in respect of expenditure incurred by the SSC in relation to income which does not form part of the total income under this Act. Now, this provision, Malad, subsection 1 or section 14A was introduced by Finance Act 2001 with retrospective effect from 1976. But later a proviso was inserted that it will not affect the earlier assessments completed. Now, kindly see, interestingly, my lord, subsection 2 and subsection 3 were introduced by Finance Act 14/2007. Now, kindly see subsection 2. Kindly see the footnote. Footnote says 85, says inserted by the Finance Act 2006 with effect from 1/4/2007. Now, kindly see subsection 2. The assessing officer shall determine the amount of expenditure incurred in relation to such income which does not form part of the total income under this Act in accordance with such method as may be prescribed. If the assessing officer, having regard to the accounts of the SSC, is not satisfied with the correctness of the claim of the SSC in respect of such expenditure in relation to income which does not form part of the total income under this Act, the provisions of subsection 2 shall also apply in relation to a case where an SSC claims that no expenditure has been incurred by him in relation to income which does not form part of the total income under this Act. So my claim before the assessing officer was that I did not incur any expenditure in relation to the exempt income that I have earned. So I fall under subsection 3, and by virtue of subsection 3 saying that the formula prescribed under subsection 2 will apply, I am covered by subsection 2 and 3. Now, this prescription of the formula, my lord, is by Rule 8D. Now, kindly see Rule 8D. Subsection 2 or 3 do not provide any estimation. My lords may kindly note. It says as prescribed. It can only be done as prescribed. No estimation is permitted under subsection 2 or 3. Kindly see Rule 8D. In the rules, my lord, it is at page 1.119. 118, I'm sorry. My lords have that?
Yes.
Now, kindly see, my lord, Rule 8D, white footnote 50, was introduced from 24/3/2008. So it can apply only from assessment year 2008-9. Earlier, the department was taking, the revenue was taking the stand that it applies retrospectively. That the Honorable Supreme Court in SR has held that it does not apply retrospectively, it applies prospectively from assessment year 2008-9. Now, kindly see, I'll read Rule 8D also because for the other questions in the other year, Rule 8D also has some bearing. 8D1 says, where the assessing officer having regard to the accounts of the SSC of a previous year is not satisfied with the correction of the claim, correctness of the claim of expenditure made by the SSC or the claim made by the SSC that no expenditure has been incurred in relation to income which does not form part of the total income under the Act for such previous year, he shall determine the amount of expenditure in relation to such income in accordance with the provisions of Sub-Rule 2. So Sub-Rule 2, my lord, prescribes a formula. Now the Sub-Rule 2, which your lordship see in the main provision, has been amended. What your lordships will have to see is the Sub-Rule 2 for these years is the one at footnote 51. Because Sub-Rule 2 was amended with effect from 2/6/2016. We are in assessment years 2007-8 and 8-9. So Sub-Rule 2 prescribes a formula. The expenditure in relation to income which does not form part of the total income shall be the aggregate of following amounts, namely the amount of expenditure directly relating to income which does not form part of total income in a case where the SSC has incurred expenditure by way of interest during the previous year, which is not directly attributable to any particular income or receipt, an amount computed in accordance with the following formula, namely, a formula is given, my lord, A into B, B by C. A is defined to be amount of expenditure by way of interest. B is defined to be average value of investment. C is defined to be the average of total assets. And 3 says an amount equal to 0.5% of the average of the value of investments. Now, in both the assessment years, what the assessing officer has done is he has applied Rule 8D23 and disallowed the expenditure to the extent of 0.5%, 0.5% of my total investments, average investments. So there are 3 points which I am trying to make. One is subsection 2 and 3 of section 14A came only with effect from 1/4/2007. Subsection 2 says the disallowance has to be made as prescribed. The prescription has come and was introduced by Rule 8D only from 24/3/2008. Subsections 2 and 3 don't provide for any estimation. Neither does Rule 8D provide for any estimation. It has to be in terms of the formula prescribed under Rule 8D2. And Rule 80 has been held to be prospective, applicable from assessment year 2008-9 by the Honorable Supreme Court in SR. Now kindly take the judgment of the Honorable Supreme Court in SR, which is part of my case law compilation. My case law compilation, page 34, my lord. My lords, may kindly come to, it's a quite a lengthy judgment. Basically, the issue considered was whether Rule 80 applies retrospectively or prospectively was the question before the Honorable Supreme Court. Kindly come to page 50, paragraph 48. Applying the principles, my lords have that?
Yes.
Applying the principles of statutory interpretation for interpreting retrospectivity of a fiscal statute and looking into the nature and purpose of subsection 2 and subsection 3 of section 14A, as well as purpose and intent of Rule 80, coupled with the explanatory notes in Finance Bill 2006 and the departmental understanding as reflected by circular dated so-and-so, we are of the considered opinion that Rule 80 was intended to operate prospectively. It is relevant to note that the impugned judgment in this appeal relies on earlier judgment of the Bombay High Court in so-and-so, wherein the division bench of the Bombay High Court, after elaborately considering the principles to determine the prospectivity and retrospectivity of the amendment, has concluded that Rule 80 is prospective in nature. Against the aforesaid judgment of the Bombay High Court dated so-and-so, an appeal was filed filed in this court, which has been decided by its judgment reported in so-and-so. This court, while deciding the above appeal, repelled the challenge raised by the SSC regarding wires of section 14A. In para 36 of this judgment, this court noted that with regard to retrospectivity of the provisions of revenue had filed an appeal. Hence, the said question was not gone into in the aforesaid appeal. In the above case, this court specifically left the question of retrospectivity to be decided in other appeals filed by the revenue. We thus have proceeded to decide the question of retrospectivity of Rule 8D in these appeals in view of our opinion as expressed about dismissal of the appeal by the Bombay High Court is fully sustainable. As held above, the Rule 8D is prospective in operation and could not have been applied to any assessment year prior to assessment year 2008-9. Therefore, the first appeal, which is assessment year 2007-8, the disallowance under Section 14A could not have been made at all in view of the subsequent judgment of the Honorable Supreme Court in the case of SR. Now, this judgment, Your Lordships, then of course, Your Lordships are aware of the judgment of the Honorable Supreme Court in the case of BC Srinivas Shetty also, which says that without a computation provision, the main provision cannot fails. So here the computation itself has come in with effect from 24/3/2008, applicable for assessment year 2008-9. When there is no computation and when the provision does not provide for estimation, the officer could not have done any disallowance on the basis of estimation, and there is no question of remand back to the officer for doing an estimation, like my learned friend submitted. Yes. Now, this judgment of the Honorable Supreme Court, my lord, has been followed in somewhat similar circumstances by Your Lordships. If Your Lordships kindly see page 58, my lord, Syndicate Bank. These are all assessment years prior to 2008-9. And if my lords kindly see the question at page 59, second question. My lords have that? Page 59, the second question. Whether the provisions of 14A of the Act, read with Rule 8D of the should be made applicable to all pending matters, as the same is clarificatory in nature in view of the consistent stance taken by the department. This question, my lords, have answered in para 10 at page 61. Yes. Para 10, from the bottom, my lords, about the 7th line. So far as substantial question of law number 2, my lords have that? Yes. In ITA number so-and-so is concerned, the same is squarely covered by the decision of the Supreme Court in CIT versus SR, wherein it has been held that provisions of 14.8 should be, my lord, read with Rule 8D of the income tax rules are prospective in nature and cannot be applied to any assessment year prior to assessment year 2008-9. Accordingly, the aforesaid substantial question of law is answered against the revenue in favor of the SC. This again, my lord, in Ingersoll Rand, which is the next judgment at para 62. Your Lordships have also said that no ad hoc disallowance can be done. Kindly see para 11 at page 65. Para 11 at page 65, my lords. My lords have that? It is pertinent to mention here that subsection 2 and 3 of section 14A were incorporated by Finance Act with effect from 1/4/2007, and prior to it, there was no mechanism to compute the disallowance on the expenditure for earning exempt income. In the absence of any mechanism, ad hoc allowance, disallowance, it should be disallowance, could not have been made in the absence of any material with regard to actual expenditure. It is pertinent to mention here that SR Teleholdings, the Supreme Court has held that subsection 2 and 3 are prospective nature and have to be utilized for computing expenditure for the assessment year 7-8. 2 and 3 came in 7-8, but Rule 8D came in 8-9 and onwards. In the absence of any mechanism to compute the disallowance as expenditure incurred for earning exempt income, the tribunal grossly erred in setting aside the order of the Commissioner of Income Tax Appeals. Therefore, the second substantial question of law is answered in negative and in favor of the SC. That was also a case, my lord, where ad hoc disallowance was made. Your Lordships have said that prior to assessment year, of course, what your Lordships have mentioned is 7-8, which is with reference to subsections 2 and 3 of section 14A. But like the Honorable Supreme Court said, Rule 8D came in 2008-9. So 14A, subsection 2 and 3 read with Rule 8D have come into effect only from assessment year 2008-9 and have no application prior to it. and no ad hoc disallowance or a disallowance on an estimation can be done by the assessing officer before assessment year 2008-9. Therefore, my lord, my first submission is that question of this additional question of law, which goes to the root of the matter, and that question of law I could not have raised in the appeal because the judgment of the Honorable Supreme Court came after I filed the appeal. Therefore, your lordships may kindly formulate. Your lordships have the power as proviso 4 of section 268. During the course of hearing, your lordships have the power to. Yes, so it goes to the root of the matter. Your lordships may kindly answer that question in favor of the SC. Now,
What about the other appeal?
Other appeal, my lord. The other two questions in this appeal and the other, first question in this appeal, which was framed, and the first question in the other appeal are regarding the satisfaction to be recorded by the officer. Now, what happened, my lord, in this, in both the years, D-Horse, my submission that for 7, 8, 14 has no application at all. I voluntarily gave a computation to the assessing officer saying that if at all this much expenditure can be disallowed under section 14A. Now, what the officer does is, without recording the satisfaction, a satisfaction that the expenditure that I have offered for disallowance is not correct, he mechanically applies Rule 8D. In law, my lord, that is not permissible, because your lordships have seen sections, subsection 2 and 3 of section 14A and Rule 8D. Now, Rule 8D, subsection 1, your lordships, the language is very clear that if the assessing officer does not accept my computation of disallowance, or if he does not believe that my statement that I have not incurred any expenditure, he has to record a satisfaction that my statement is incorrect, and that only then he can apply Rule 8D, subsection 2, the formula that is prescribed. Now, that, my lord, if your lordships kindly see the appeal for 8-9, which is 1001 of 2017, kindly see the assessment order at page 29, annexure D. First, I will demonstrate that the assessing officer has not recorded that satisfaction. Then I will take your lordship to the law which says that satisfaction is necessary to be recorded before any disallowance is made. Kindly turn to, my lord, para 7, page 31. My lords have that? Page 31, para 7. During the course of assessment proceedings, the SSC's AR was asked to furnish the details of expenditure attributable to earned exempt income. In response, the SC's AR filed his submission on 5/12/2014. In that submission, my lord, I also offered a computation to disallow certain expenditure that comes out in the CIT appeals order. I'll take your honors to that. The SSC's reply has been considered but not entirely accepted. The SSC company has been given several opportunities to substantiate its claim, but the SSC company has failed to prove its contentions conclusively that no indirect expenses were incurred to earn the exempt income. My lord, I cannot be asked to prove the negative. When I say that no expenses have been incurred, how can I demonstrate that no expenses have been incurred? The burden is on the revenue to show that I have incurred expenses. The officer is placing burden on me. It's a basic principle of rule of evidence. That how can I prove that no expenses have been incurred? If the officer claims that I have incurred expenses, the onus is on the officer to show that I have incurred expenses. So that statement that he says that I have not produced any evidence that I have not incurred expenses is not correct. It would be fair to note that investment decisions are complex in nature, and a company is run by its board of directors, and the business and investments are managed by its team management personnel, accountants, executives, etc., for which experts are often consulted. The very existence of corporate identity and its structure requires an administrative establishment which requires incurring of multifarious expenses, including establishment, general and administrative expenses. The mandate of Section 14A requires the SC to maintain proper books of accounts in regard to the investment made from which the income can arise, which is tax exempt, and such books of accounts be produced before the assessing officer to ascertain the expenditure incurred in relation to income not includable in the total income. I'll just pause here, Manoj. This is also not correct because 14A doesn't say anywhere that I have to maintain separate books of accounts for the purpose of investment. In the instant case, the SSC has not maintained any separate account nor furnished with documentary evidence in this regard. This proves that the claim of not incurring any expenditure in relation to tax-free income to be earned from its investments is not supported by documentary evidence as mandated by 14A2 and 3. 14A2 and 3 does not require any maintenance of separate accounts. In other words, under the given facts and circumstances, the SC has not discharged the onus placed upon it. Again, it is incorrect. In the absence of the accounts maintained by the SC in regard to its investments, the AO cannot examine the claim of the SC having regard to its accounts. However, since the incurrence of the establishment expenses, other administrative and general expenses, etc., cannot be ruled out in regard to maintaining of investment portfolio coupled with fact of investment. So, general, my lord, I will not trouble reading the entire assessment order. Everything is general. He just says that because 14A provides for disallowance of expenses, and I may have incurred certain expenses in making the investments and earning exempted income, he makes the disallowance. If my lords will kindly see at para 19, applying section 14A read with rule 8D. So nowhere, my lord, satisfaction has been recorded that I have not, my statement that I have not incurred any expenses towards exempt income or whatever I have offered is not correct, which is the basic requirement under Rule 8D1. Recording of satisfaction is a sine qua non for application of subrule 2 of Rule 8D. That is the proposition that I am making, my lord. Now, kindly see, my lords, the assessing officer has not made even a whisper about what I have offered for disallowance during the course of assessment proceedings, which has been actually recorded by the CIT appeals. Kindly come to the CIT appeals order, page 37, annexure E, and kindly turn to page 40, which is para 5, the discussion starts. I will not trouble your lordships with that. Kindly come to page 42. During the course of set-aside assessment, my lords have that, the appellant has pleaded before the AO that following may be treated as net expenditure towards earning of exempt income and treated as disallowance under 14A. So I have said that 1,61,035, if at all, can be attributed to my as my expenses towards exempt income with a formula that I have given. Now, first of all, my submission, my lord, the CITA notes that I have given this computation before the assessing officer. Assessing officer nowhere in the order says that I have given this computation is not correct, and records a satisfaction. He goes on general principles of section 14A and rule 8D. Yes. Now kindly see what the tribunal does. The tribunal's order is at page 44. Kindly come to page 47, para 5, the last 4 lines, my lord. Regarding AY 2008-9, my lords have that? Yes. We find that the expense was incurred on account of salary and travel cost, but from this year, Rule 8D is applicable, and therefore disallowance has to be made as per Rule 8D in this year. Regarding this submission of the learned AR of the SC, that out of the total investments of so and so, the dividend income has been earned from one company only in which the investment was so and so, we find that the AO has considered only one investment for making disallowance of 34 lakhs at the rate of 5%. So the tribunal also doesn't go into sub-rule 1, which says that satisfaction, it says subsection 2, sub-rule 2 applies. But sub-rule 2 can only apply if satisfaction under sub-rule 1 is recorded that my expenditure that I have offered is incorrect, or that my statement that no expenditure incurred has been proved to be incorrect by the assessing officer. The onus is on the assessing officer. Now, for this proposition, my lord, I am relying on first to say, my lord, the satisfaction is necessary to be recorded. Kindly turn to the judgment of the Honorable Supreme Court in the case of Godrej and Boyce, which is the third judgment in my case law compilation, page 13. And if your lordships could kindly turn to para 37 at page 27. Let me just clarify here, my lord. Godrej and Boyce, the Honorable Supreme Court judgment was prior to SR. So in SR, as I noted in SR, my lord, in Godrej and Boyce, they did not go into prospectivity and retrospectivity of Rule 80. Therefore, although some of the assessment years in Godrej and Boyce were prior to 2008-9, that question was not gone into. Now, kindly see para 37. We do not see how, my lords, have that.
Yes, yes.
Page 27, para 37. We did not see how, in the aforesaid fact situation, a different view could have been taken for the assessment year 2002-3. Subsections 2 and 3 of section 14A of the Act, read with Rule 8D of the rules, merely prescribe a formula for determination of expenditure incurred in relation to income which does not form part of the total income under the Act, in a situation where the assessing officer is not satisfied with the claim of the SSE. Where such determination is to be made, an application of the formula prescribed under Rule 8D or in the best judgment of the assessing officer, what the law postulates is the requirement of a satisfaction in the assessing officer that, having regard to the accounts of the SSE as placed before him, it is not possible to generate the requisite satisfaction with regard to the correctness of the claim of the SSE. It is only thereafter that the provisions of section 14A 2 and 3, read with Rule 8D of the rules, or a best judgment determination as earlier prevailing, would become applicable. Therefore, the Honorable Supreme Court said that before invoking the formula prescribed under Rule 8D, satisfaction to be recorded by the assessing officer is a must. My lord, this has been followed, my lord, subsequently in somewhat identical circumstances by the Delhi High Court, which is a more elaborate judgment. Therefore, I'm citing that. Kindly see page 29 in Eicher Motors Limited. And kindly turn to para 6 at page 32, my lord. My lords have that. The SSE had also earned dividend income of rupees so and so from investment in subsidiary companies and mutual funds that were exempt under section so and so. The SSE, however, did not disallow any expenditure in respect of the earnings of the above exempt income. And kindly come to para 8. The AO further invoked section 14A of the Act and computed disallowance of rupees so and so. The reason that weighed with the AO in making the above disallowance as regards the exempt income was that the AO observed that the 14A was a straightaway attracted, but no expenses were claimed. The AO then surmised that certain expenses ought to have been incurred for earning the dividend income, like purchase of raw materials, salaries, etc. That AO proceeded to apply Rule 8D, sub Rule 2 and 3 of the income tax rules as applicable at the relevant time and worked out the disallowance as rupees so and so. Then I'll skip para 9 and 10, my lord. Kindly come to para 11. As regards the issue concerning disallowance under section 14A of the earning exempt income, the ITAT again concurred with the SC that the AO had failed to record reasons for disagreeing with the SSC that it had not incurred any expenditure in relation to earning of exempt income. Nevertheless, on this issue again, the ITAT remanded the matter to the CITA to decide the issue afresh. A direction was issued to the CITA to call for a remand report from the AO and to record his satisfaction and cogent reasons before invoking the provisions contained in 14A read with Rule 8D of the IT rules. Then I'll skip para 12, my lord. Kindly come to para 13. As regards the disallowance of expenditure for earning exempt income in terms of section 14A of the Act, the settled legal position is that the AO had to record reasons for disagreeing with the submission of the SSC that it had incurred no expenditure for earning such exempt income. This is plain even from Rule 8D1, which requires the AO to mandatorily record his satisfaction that the claim made by the SSC that no expenditure had been incurred is incorrect, having regard to the accounts of the SSC. In this case, a perusal of AO's reasoning shows that the AO has merely conjectured that there is an inbuilt cost, even in passive investment, as also incidental expenditure like collection, telephone, follow-up, etc. The AO thus concludes that the expenses are embedded as indirect expenses. This is not as per the requirements of Rule 8D. There is no satisfaction recorded based on the accounts of the SSC. The AO simply presumes that since the exempt income exists and is being claimed by the SSC, some portion of the expenses ought to be added back. This is not sufficient as per law. Once this mandatory requirement is itself not fulfilled in terms of the law explained by this court in Maxop so-and-so, the question of remanding the matter to the CITA and to call for a remand report from the AO for the purpose of rectifying this jurisdictional defect simply did not arise. In this context, the court also notices that the order passed by the AO on so-and-so pursuant to the impugned order of so-and-so on remand, the AO had simply repeated his entire assessment order passed in the first instance. Be that as it may, the court is of the view that the ITAT erred in overlooking the correct legal position in remanding the matter to the CITA. Accordingly, both the questions are answered in favor of the SSC. Therefore, my lord, relying on the Maxop, the earlier judgment of the Delhi High Court, which subsequently has been affirmed by the Honorable Supreme Court, which my learned friend has cited, even in Maxop, Supreme Court says that the recording of satisfaction is a sine qua non for invoking sub-rule 2 of Rule 8D. That satisfaction has not been recorded in this case by the assessing officer, as I already pointed out. He neither records satisfaction that I have not incurred any expenditure, and in fact, the computation, I voluntarily, to buy peace, I said, okay, you disallow this expenditure, this is the formula I am giving. That the assessing officer does not even discuss. So without recording satisfaction, the disallowance made by him and upheld by the ITAT, without seeing the law on the point, is the incorrect, my lord. Now this recording of satisfaction, my lord, incidentally, your lordships also have taken a view. In the case of Hindustan Aeronautics, if my lords kindly see page 8. My lords have that, page 8, and if my lords kindly turn to page 10, para 8. My lords have it?
Yes.
With regard to claim of the SSC under section 14A of the Act, it is pointed out that the SSC has earned dividend income from 2 companies in which it made strategic investments, which was exempt under section 1034. And since no expenses were incurred to earn the exempt income, the SC did not make any disallowance under 14A. The assessing officer made a disallowance of 14A by applying Rule 8D3 on 0.5%, as it is done in this case, of the investments without recording any satisfaction as to the incorrectness of the claim of the SC. And in the absence of recording satisfaction, Rule 80 of the rules could not have been invoked. In support of the aforesaid submissions, reliance is placed on Godrej Boys Eicher Motors. On the other hand, the learned counsel for the revenue submitted that the SC in his submissions made before the assessing officer on so-and-so has clearly admitted the expenditure incurred result in acquisition of capital asset, and therefore the tribunal on submissions of admission made by the SC has rightly held that the expenditure incurred by the other is capital. That is not relevant. What is relevant is about the last 5 lines, the last 6 lines. However, the assessing officer claimed that it had incurred no expenditure in earning the dividend income. Therefore, the assessing
Para
officer.
12, Mr. Para 12. Para 12.
I'm sorry, Para 12, yes. So far as the claim of the SSE under section 14A of the Act is concerned, subsection 2 and 3 of section 14A of the Act, read with Rule 80 of the rules, prescribe a formula for determination of expenditure incurred in relation to income, which does not form part of total income under the Act in a situation where the assessing officer is not satisfied with the claim of the SC. The sine qua non for invocation of power under section 14A of the Act, read with Rule 80 of the rules, is recording of satisfaction by the assessing officer that having regard to the accounts of the SC, it is not possible to arrive at the satisfaction with regard to the correctness of the claim of the SC. In the instant case, the assessing officer has not recorded any satisfaction with regard to the genuineness of the claim of the SSE before invoking powers under 14A of the Act, read with Rule 80 of the rules. And the question was answered in favor of the SC. Now, for the point that the onus is on the department, my lord, and not on the SSE, that no expenditure has been incurred, I'm relying on one judgment, my lord, of the Honorable Bombay High Court, which is at page 1. And if my lords kindly turn to page 5. Para 17, my lord. My lords have that. Recently, this bench disposed of a batch of tax appeals. One of the substantial question of law that was identical to the one before us, rejecting the revenues contention. This court has noted that the respondent invested certain parts in exempted categories as mutual funds, it earned income. During the assessment year, income from sources stood exempted under 1035 of that. The only issue was whether the respondent incurred any expenditure while earning the exempted income and whether it included that expenditure in the common indirect expenses of its own. First, the appellant noted, rather guessed, that the respondent borrowed funds to invest and that there ought to be an interest element. But the respondent asserted that it utilized its surplus funds. This court then found that there was no material for the appellant to conclude that the respondent borrowed the funds. Second, given the volume of investment, the respondent is said to have received charge-free services from managers of the bank and other financial institutions with whom they have invested. So there is said to be no expenditure. And kindly see para 19. Here on facts, the tribunal noted that the AO only discussed the provisions of 14A1 but has not justified how the expenditure SSE incurred during the relevant year related to the income not forming part of its total income. The AO, according to the tribunal, straightaway applied Rule 8D. Indeed, there must be proximate relationship between the expenditure and the tax-exempt income. Only then would a disallowance have to be effected. This court, we may note, my lord, kindly see, this court, we may note, on more than one occasion has held that the onus is on the revenue to establish that there is a proximate relationship between the expenditure and the exempt income. That is, the application of 14A and Rule 8D is not automatic in each and every case where there is income not forming part of total income. No doubt the expenditure under 14A includes both direct and indirect, but that expenditure must have proximate relationship with the exempted income. Surmise or conjecture is no answer. So my submission, my lord, is when I say I have not incurred any expenditure, but and on the other hand, I myself offered something to this thing without saying how it is incorrect, without demonstrating or bringing in any material to show that I have actually incurred some expenses, no disallowance could have been done by the assessing officer, and that too without recording a satisfaction. Therefore, my lord, all the substantial questions of law may be answered in favor of the assessor.
Yes, sir.
My lords, I may be permitted, my lord, to just to reply this petition, my lord, so that I can refer to, my lord, the very same compilation, my lord, which my learned friend has placed, 2008-9, my lord, second appeal first. May, my lord?
Yes.
My lords, may kindly turn to, my lord, the first judgment, my lord, in the compilation, that is the Hindustan Aeronautics, which Mr. Surya, my lord, has placed, just referred to, my lords. In the same compilation, my lord.
Yes.
My lord, the compilation is common for both the appeals, my lord. I didn't want to add more papers.
It's your lordship's order, my lord, in the case of Hindustan Aeronautics, my lord, at page number 8, it starts. Lord, I'll just take, my lord, invite your lordship's attention to only to few sentences, my lord, in the paragraph. My lord, page 12, my lord, para 12. Last 3 lines, my lords, may kindly notice. In the instant case, the assessing officer has not recorded any satisfaction with regard to genuineness of the claim of the assessee before invoking the powers under section 14A of the Act, read with rule 8D of the rules. Lord, why am I referring to this, my lord? In the present case, my lord, for 8-9, Lord, the assessing officer, my lord, has my lord, in fact, my lord, recorded reasons, my lord, for as required under 14A, and as your lordships have held that recording of, my lord, reasons, my lord, satisfaction, my lord, is mandatory. My lord, that mandatory condition, my lord, has been complied with, my lord, at page number, my lord, at para number 8, 9, my lord, of the 8, 9, 10, my lord, of the assessment order, and 11. These are all cases where, my lord, there was no even, my lord, whisper about, my lord, any, my lord, incorrectness of the claim of the assessee. In this case, my lord, the assessing officer has recorded, my lord, the satisfaction as required, as mandated, my lord, as laid down by lordships. My lord, even in the case of, my lord, Godrej Buoyance also, my lord, it was a case of no satisfaction. My lord, the Honorable Supreme Court said, my lord, held that, my lord, the satisfaction has to be recorded. There is no quarrel, my lord, as on today, that, my lord, whether satisfaction has to be recorded or not. My lord, here the fact that, my lord, the assessee himself, my lord, in the course of assessment proceedings, my lord, offered to certain partial disallowance, my lord, which was not there in the return of income, that itself shows that, my lord, the incorrectness claim of, my lord, the no expenditure, my lord, claim by the assessee itself. The very fact of the assessee offering, my lord, certain disallowance would show. My lord, that is what, my lord, the assessing officer, my lord, has recorded, my lord, at para 8, 9, and 10 is concerned. Lord, I will not trouble your lordships because my learned friend, my lord, has read, my lord, your lordships, the reasons recorded. Your lordship kindly note down paragraphs, my lord, 8, 9, and 10, my lord, of the assessment order. Those 3 paragraphs, my lord, complies with, my lord, or refers to, my lord, the satisfaction as mandated. But even, my lord, the same the mandate, my lord, has been held, my lord, by the Honorable Supreme Court in the case of, my lord, Godrej and Buoyance, my lord, at page number 13, my lord, of the compilation. Similarly, my lord, of the Delhi High Court, my lord, in the case of, my lord, Eicher Motors. I'll not repeat your lordship, my lord, on that aspect. Hence, my submission, my lord, is as the satisfaction has been recorded, my lord, and the application of, my lord, the formula, my lord, is justified. If for any reason, my lords, if my lords are not with me, my lord, at least the disallowance, my lord, what has been admitted, my lord, as an expenditure offered before the AO, my lord, which should have been recorded, my lord, in the order. That, my lord, the assessee offered it and he is refusing it. But that there is no finding. To that extent, I think, my lord, at least, my lord, the disallowance should be, my lord, be made, my lord. Whatever it has been offered by the assessee itself. My first submission, my lord, just to conclude, my lord, on this appeal, satisfaction has been recorded. The offer made by the assessee for disallowance itself shows, my lord, the incorrectness of the claim. Thirdly, my lord, if for any reason, my lord, if my lords are not with me, my lord, on that, my lord, the offer made by the assessee, my lord, regarding the disallowance, my lord, needs to be upheld. My lord, insofar as, my lord, the second appeal is concerned, my lord, yes.
Yes, Mr.
The second appeal, my lord, is concerned, my lord, as my lord has rightly, my lord, the contended by the assessee, my lord, the rule 8D, my lord, may not be applicable. My lord, still, my lord, the estimation, my lord, is not taken away. And your lordships, my lord, have held that, my lord, ad hoc, my lord, is not permissible. My lord, in this case, my lord, the extent of, my lord, ad hoc has not gone into, as it is not an ad hoc basis. My lord, once the applicability of rule 8D, my lord, is taken away, my lord, under 14A 1 and 2, my lord, the estimation has to be made. Your lordships have held that, my lord, ad hoc disallowance cannot be made. Ad hoc disallowance, my lord, in that some round figure has been taken. My lord, if my lords kindly notice, my lord, the syndicate bank judgment, my lord, at serial number 1, my lord, is the same compilation for a minute. My lord, questions, my lord, at page number 58, my lord, for a minute, my lord. But whether the tribunal, my lord, at page number 58, foot of the page, my lords, whether the tribunal was correct in holding that the estimation of expenditure in respect of administrative or financial cost at 5% of the dividend income earned by the assessing officer in accordance with section 14A of the Act cannot be disallowed. Whether the provisions of section 14A of the Act read with Rule 8D, my lord, 2 deals with, my lord, application of Rule 8D. Now, my lords have dealt, my lord, these 2 questions, my lord, independently, my lord, at page number 9 and 10, para 9 and 10, my lord, at page 61. My lord, para 10, my lord, has been pointed out to your lordships, my lord, so far as, my lord, applicability of Rule D, saying that, my lord, it is prospective, it is not applicable, my lord, for the assessment year involved in this case. Because the assessment year, my lord, is 2000-2001. Para 9 for a minute, may kindly notice, my lord. From the perusal of section 14A of the Act, it is evident that for the purpose of computing the total income under this chapter, no deduction shall be allowed in respect of the expenditure incurred by the assessee in relation of the income which does not form part of the total income under the Act. The expenditure, the return of investment and the cost of acquisition are distinct concepts. Therefore, the word incurred in relation to section 14A of the Act has to be read in the context of the scheme of the Act, and if so read, it is clear that it disallowed certain expenditures incurred to earn exempt income from being deducted from other income which is includable in the total income for the purposes of chargeability to tax. It is equally well settled that expenditure is payout. In order to attract applicability of section 14A of the Act, there has to be a payout and return of investment, or payback is not such a debit item. In the instant case, the assessee has admittedly not incurred any expenditure. This case pertains to income on dividend, which by no stretch of imagination can be treated as an expenditure to attract the provisions of section 14 of the Act. In view of the aforesaid enunciation of law by the Supreme Court, the first substantial question of law framed by this court is answered in favor of the assessee and against the revenue. My lord, one more paragraph, my lord, in the next judgment, my lord, in the case of Ingressor. My lord, at para 11, my lord, the second of, my lord, at the, my lord, at on the right hand side, my lord. My lord, that your lordships, my lord, have dealt with, my lord, the ad hoc disallowance. My lord, why, my lord, I was submitting, my lord, is for the remand, my lord, is concerned. My lord, as on that day, my lord, the impression, my lord, was Rule 8D, my lord, being a clarificatory. My lord, assessing officer has applied them. My lord, applicability of the formula, my lord, straight away, my lord, has been negatived, my lord, by the Honorable Supreme Court. Now, my lord, what, my lord, this is a case appeal against an order of remand. My lord, what exercise, my lord, remains is para 9, my lord, which I read to your lordships, my lord, in the syndicate bank, whether there was an actual payout or not. My lord, that issue was never gone into, my lord, because the assessing officer straight away applied Rule 8D. And of course, my lord, in this case also, my lord, the satisfaction condition, my lord, has been complied with. Now, my lord, in 8-9, my lord, after recording satisfaction, my lord, he can apply Rule 8D. In this case, my lord, without applying Rule 8D, my lord, because the satisfaction about incorrectness of the claim made by the assessee has been recorded, my lord, he is entitled to, my lord, estimate, but not, my lord, an ad hoc basis with subject to, my lord, certain, my lord, the material. My lord, as your lordships, my lord, have held at, my lord, para 9, my lord, of the syndicate judgment. Please, your lordship.
My lord, just 2 points, my lord. The para 9 of the syndicate bank judgment, which my learned friend read, actually supports my case. What your lordships have said is basically what I was saying, that the officer has to bring in material to show that I have actually incurred expenses. Without that material, no disallowance can be done, and it cannot be on an estimation or ad hoc basis. Now, as far as the point made by my learned friend, that in paras 8, 9, and 10 of the assessment order, satisfaction is recorded, my submission is that cannot be said to be satisfaction. What the Honorable Court and the your lordships have said is satisfaction should be that the expenditure I have, that my claim that no expenditure has been incurred should be recorded. Satisfaction to that extent has been recorded. To record such satisfaction, the assessing officer has to necessarily bring in material. To show that I have incurred expenses, as your lordship rightly said in para 9 of syndicate back.
You say with regard to this that offer of disallowance made by you to the
Yes, in the assessment year 2008-9, my lord, I have voluntarily offered 1,61,035.
To that extent, it should be upheld.
To that extent, since I have voluntarily offered, my lord, in the second round just to buy peace, my lord, that is actually not. I wanted to put an end to the litigation, and therefore I have offered. But my lord, page 42, it is noted 1,61,035. That, my lord, I will have to, since I have myself offered it during the course of assessment proceedings, your lordships may direct the assessing officer to disallow only to that extent.
Lord, I'm sorry.
Only for assessment year 8-9.
Lord, I'm sorry, my lord, with your lordship's permission, my lord. One, the judgment, my lord, I should have drawn your attention, my lord. I have handed it out to the court officer, my lord, in max up. Just three lines, my lord, in that for record purpose.
Max up. Yes.
Para 41, my lord. I'm sorry, my lord. My lord, this is only for the proposition that, my lord, the satisfaction would be required when, my lord, the assessing officer, my lord, the assessee, my lord, makes an apportionment. And if that apportionment, my lord, is disagreed, my lord, then only the question of satisfaction doesn't, the recording of satisfaction arises. But if, my lord, kindly notice, third line, my lord, it will be in those cases where the assessee in his return has himself apportioned, but the AO was not accepting the said apportionment. In that eventuality, it will have to record satisfaction to this effect. The satisfaction mandated, my lord, under 14A2, my lord, by the Honorable Supreme Court is only in a circumstance when, my lord, the assessee disallows certain amount. If I am, my lord, disagreeing with that, if it is a case of, my lord, no disallowance by the assessee on its own, my lord, the question of recording a satisfaction doesn't arise, my lord, is much so. Only for that proposition. Sorry, my lord.
That is why, my lord, I am offering 1,61,000 as a disallowance. I am not this thing because I have myself offered. It may not have been in the return of income, but during the course of assessment. And I would only submit, my lord, your lordships may see para 32 and 33 of that judgment also of Maxop, where they have clarified that satisfaction has to be recorded, even for making any kind of disallowance.
Yes.
Para 32 and 33 also has to be read with para 41 is my submission. That's all. Lord, for both the appeals, I filed the written submissions, my lord. Yes. Grateful, Your
Honor. 37, M.A. Sebastian, government advocate, C.R. Mahendra.
Which case?
37.
Appear for the petitioner, please.
Nobody is none. Mr. M.A. Sebastian, none for respondents. Even when matters called in second round, awaiting appearance of learned counsel for respondents. This effort, this after 1 week.
28, Sri M.R. Vijay Kumar.
I appear for the respondent in serial number 38 for 1 and 2 and the petitioners in 38A. Lords, the counsel is not keeping well. He is in the quarantine. Kindly have it on 3rd or 4th, Lords.
It is unwell list on 4th February.
4th February. Much obliged.
Number 44, Srimati Sanali Shendge, Sri K.V. Arvind.
Yes, my lord.
Next week, Mr. Arvind.
Please, my lord.
Yes. Next week, now no time left.
Please,
my lord. My lord, can we then have it on the 5th, my lord, then?
5th?
Yes, my lord.
Saturday. 5th is Saturday.
Oh, 4th, my lord, 4th.
Friday?
Yes.
Mark the judges, learned senior counsel. Mr. K.V. Arvind, learned counsel for revenue. On account of paucity of time, the matter could not be taken up. Next on 4th February 2020.
Extremely grateful, my lord.